telling me I have email. Oh, because I do have email.
Hello?
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 Is this working?
Hello?
Yes, it's working. I always like to check to make sure that we're working, because, you know, it's a good easy way to break stuff if you just don't test it's working before you actually start it to work.
Why is my screen so pixelated?
It's because it happens on my end for some reason. Let me see if I can redo it. I meant to do something. That's what I meant to do. I meant to mute the music, because we don't need to be having that over us. It's gonna happen a million times because Discord's really good, but they have a few issues. So let's get this show on the road. Hi everybody. It's time to start Dan's Stream of Thought right here on twitch.tv/StreamerSquare. Well, let's get it. I like to start off with just chillax with everybody for a second. It looks like people are slowly rolling in, and so we might as well just do the intro. Let's do it. Welcome to an all-new episode of Dan's Stream of Thought, the podcast that can hear themselves echoing every now and then because I happen to be in the same room as another guest on the podcast today. I'm joined by two lovely people. We'll get to them in 1 second, but first of all, this show is going to be heavy with some good stuff, some things you may or may not have thought about, some things that may confuse you as they might confuse me, but that's why I brought actual specialists on here, the people who know what the heck they're doing, and let's actually introduce them. So first, I am joined by somebody I met, let's see, about 6.5 years ago. We met in a college classroom, and yeah, it was like we were doing some like podcast thing, and like, no, it's yes, that's all true actually. But I met the lovely Lady Laumies, aka ThatOneKnave, who happens to be next to me. Katie. Hi, Katie.
Hi. I like that you're sharing our love story just
So
on StreamerSquare.
Well, I mean, like, it was what, philosophy of science, right?
Yep.
And kids, this is how I met your mother. Am I allowed to say that? I'm flanked by two lawyers here. I gotta check make sure I know what I'm saying all the time here. I'm also joined by somebody that actually we met for the first time at TwitchCon, right? Like actually in person?
Yeah, we met first time in person at TwitchCon.
But we had been like, you know, talking and hanging out and like talking about video games and cool stuff, and this weird guy named Omid and things, and I don't know, we learned about a lot about what's going on, and we mentioned stuff about Katie getting through law school. We actually met before Katie became an attorney, which is crazy.
That is true.
I'm joined by the lovely Mona Ibrahim. I did it wrong the first time.
So we actually met because I represent your agency that represents you.
Represent, yes.
I represent Online Performers Group.
Yes, so OPG, which you all know, which a lot of the people that show up here on this this channel are represented by the lovely Online Performers Group, which has a lot of really cool people, not only in their staff but in their clientele, and it's created this whole like crazy network behind so many different things that it's just become this giant family, and obviously it's extended out to the people that represent them, like the lovely people and well, I mean, they're not represented by IE Group, right? Or how does that? I don't know how that works.
So the way that it typically works in agency relationships, and we do this to a certain extent with OPG as well. So when an agency gets a contract in, they have counsel for the agency that reviews on behalf of the client. And that way you can secure your own counsel, obviously, but that ensures that you at least have one set of legalized reviewing all contracts. And generally with OPG, it's more on an ad hoc basis when there's a contract that we think that there might be a problem with, or if it's something new.
That makes sense, because like I think a lot of what OPG does is pretty much like we see this all the time, and then you have like hyper intelligent people that look over all that, and all the people that work there Especially Jen, who is just an absolute genius. The COO, is that the correct title there?
I think
Of
she's
I think
COO or
so. Chief of
yeah.
Operation.
yeah, I
Yeah,
think so.
Chief Operations
COO.
Officer.
So you have Omid as the CEO. You have Jen as the COO. Now you have in this crazy world,
CTO.
we have a
Cole.
CTO, Sir Slosish, Slur Slosh.
There's law.
one of my closest friends, great dude. I don't think we've talked about that yet on here, but we'll talk about what a CTO is at some point in time. Oh, we did.
Chief Technical Officer.
Yeah, we did talk to him. That's right. We did bring him on the show like almost immediately after that was announced, and yeah, we talked about engagement and weird stuff. Anyway, so both attorneys at law here in the state of California, practicing
I'm
Bard.
licensed in Washington first and foremost. So.
And you're not from here. You actually moved here to practice law here, right?
I moved, so that's actually interesting. I was originally licensed in Washington. I moved to Kentucky for personal reasons. My dad passed away. Briefly, and then I was in Illinois, and then I'm in LA now. So I've just been kind of bouncing around, but I worked remotely for IELG for about 4 years before moving here.
Okay. And Katie's, you're working remotely now as well. Do you want to talk a little bit about the law you're practicing right now, or at least the law that you wish to practice in the future, or whatever it is that you want to introduce yourself with at this point?
Sure. So right now I do workers' compensation, subrogation, litigation, a lot of shuns. I want to move into entertainment law, but I think going from litigation to transactional law, so like going before a court, like all the time versus drafting contracts and revising contracts, doing negotiations, is a little bit difficult of a transition, particularly because I didn't get any transactional experience when I was in law school.
But that's why you have a mentor.
That is why I have a mentor. That's very true. So working on that, but yeah, I think being in the greater Los Angeles area is probably a good step in the right direction. So yeah.
Yeah, don't worry, chat. I'll ask the questions when they start getting too smart, and I'll be the dumb chat for you guys so that we can answer some of these things. Because yeah, go ahead.
I do want to go ahead and let people know what I actually practice, just in case there's any confusion on that point. So I mentioned the mentor things because I'm mentoring Katie, but I am a video game attorney. I've been in practice for about almost 11 years now. I work for a firm called Interactive Entertainment Law Group. We are based in El Segundo, California. We are a pretty prolific firm in terms of our market share. We represent over 350 clients exclusively in the video game industry. That includes companies like Square Enix, Bandai Namco. It also includes studios like Double Fine, Pound Sand, Unbroken, Blind Squirrel. So we and what was it? Brace Yourself.
Brace Yourself Games, yeah.
What was the Shovel Knight one?
Ooh, Shovel Knight? Shovel Knight's been doing lots of stuff.
I'm gonna.
Is it Treasure Trove?
Never mind.
No, Yacht Club.
Yacht Club, that's the one. Yacht Club Games. So they are another one. And I'm trying to remember who I can name without it being like an issue. But we represent a ton of clients all in the game space, really well connected, and I pretty much cover all bases. I'm strictly transactional, though. I've not done a day of litigation since my first year of practice.
Yeah, so you answered my next question, and it kind of leads into a little bit of talking about. So there's a lot of game companies out there that have like big publishers and stuff like that, and most of those publishers have, well, I don't even know, actually. That's probably the part of the question. I would assume a lot of big publishers like, Electronic Arts, who also develop their own games, and who 2K and stuff like that, they probably all do a lot of inside counsel, right? And it sounds like what you and your firm cover is a lot of companies who don't have these large, giant corporations that are backing them, so they seek out you guys for a lot of help.
Not necessarily. I interface with general counsel on a continuous basis. We also represent Crunchyroll games. That's probably my biggest feather in my cap because I'm a huge weeb. Like I'm a massive anime fan. So like one of my favorite things is the fact that I get to discuss anime and get anime recommendations from the people that I work with at Crunchyroll, including their general counsel.
That's awesome.
But yeah, I work with general counsel for Crunchyroll, for Square Enix. These are big corporations. They all have in-house, but there are also things that we specialize in because we are doing these deals constantly that they may not have as much experience dealing with, or that they don't have the time to deal with, especially when we're talking about bigger transactions that are not so day to day, that may involve things like equity components or various moving parts that they are less familiar with. A lot of general counsel, depending on the company, will come from a slightly different background, a more corporate background as opposed to an entertainment background. A lot of these companies are going to be looking for somebody with corporate M&A and SEC experience, especially if they plan on doing any kind of IPO. So that's going to be their emphasis as opposed to somebody who specializes in video games.
So would you say, so there's a lot of I know there's a lot of politics around like the bar and the testing and all that stuff, where you kind of have to learn a little bit of basically everything, and are meant to know how to practice a little bit of everything. But is it sort of, now we're getting into like lawyer weeds and stuff. We'll get to the subject of the episode in a second, but I'm genuinely curious. It sounds like there's a lot of referral that happens within the professionalism of being an attorney and helping people out and going from side to side, because like you said, people have specialties, and there's a lot of like, I'd rather not be responsible for something I'm not super good with, so we give it to a lot of people that may be better. Is this somewhat true, or like what's the kind of the soft details about that?
A lot of the issues I cover will range everything from employment law and general corporate law to M&A and securities and investment, to obviously licensing, IP, and all of those components. So we're fairly full service. I cover at our firm, I cover most of the regulatory stuff, a lot of the licensing deals, and then I go into the weeds on the corporate stuff a lot. So I tend to be the one heading up the seed, like the series seed rounds for equity, in order to get project financing, stuff like that. So that's where my focus tends to be, and then obviously GDPR, the regulatory framework, as I said. So in that context, I'm full service, but I won't touch tax law if I can help it. I had to do so much research on 409A that I wanted to kill myself. And 83B elections, I'm done. So I tend to refer everybody to an accountant and a tax attorney as often as possible. And then obviously, if we're dealing with games that are involved in anything concerning healthcare and HIPAA, I need a specialist for that. Not touching it. And
Can
then
attest.
things like ERISA, I actually know more about ERISA than I want to. So I really want to start referring out for that as much as possible. Like there are things that I want to refer out just because I don't want to deal with them anymore. And so now it's mostly going to my associate.
Gotcha.
Well, I mean, that's also another way to do it. Because that's what I get. Like right now, I just I catch all the overflow for a lot of the attorneys at my firm. So I just do everything, basically stuff they don't want to do.
Yeah, that's my favorite part about having.
Well, so as an attorney that is focused on looking to start to do transactional work, and I happen to know that you're very interested in contracts and what makes a contract tick and how to put together a contract, and I know that makes your wheels spin a lot, Katie. But can we talk about a little bit about what you think is sort of the more important things as to why putting together a contract and having people look it over and having like professionals actually give you advice, what makes it so important?
Well, the biggest thing is that there's, I think a lot of people have heard this word, precedent. So contracts have been litigated before, right? And courts have decided very particular things about how those contracts can be drafted and what it means when they're drafted a certain way. And basically, not only lawyers, but primarily, lawyers are in the best position to know what has come before and how to draft contracts going forward and what will protect you and what will cause you problems. I think a secondary point to that, because it's obviously a very long discussion, is that a lot of, at least I felt this way before I went to law school. So I think probably other people who are not lawyers probably also feel this way. The more ambiguous a contract is, the better it is, because then you can just argue it however you want, which is absolutely false.
I think you just made Mona cringe a little bit. I think Mona just got sick.
I have rules
I think
against
so.
that. I have rules against that.
So, as you can tell, that's not true at all. The more ambiguous a contract, the less likely it is that you are going to get your way. And the court is just going to decide for you, and you don't want that. I don't think any party wants that in a contract, in a contract dispute. So
So I have
yeah,
a philosophy about transactions.
Because
And
it sounds like a lot of things are left up to a judge, right? Because like to break it down for the layman out there, we talk a lot about like, well, actually, I don't know who cares about this, but a lot of like UFC fights and boxing and all that stuff. Almost the rule is almost always don't leave it to the judges, and that kind of goes into the real world too. Because like you never know what kind of judge you're going to get, right? And I think we had this conversation yesterday, 2 days ago, when we played. So by the way, we all played Fallout 76 the other day, which is super fun. And it's also a question I usually lead into when I totally forgot what game are you guys playing. Well, I think right now it's Fallout 76. I think fair to play, even though we only played it one day. But the thing is, like, so but I'm not only am I flanked by two people that are way smarter than me and happen to be licensed attorneys and things like that, but I think they're both, speaking as a video game broadcaster professionally, I think they're both bigger gamers than me. Because I can't sit for as long as either of you do and play one game for so long, because you guys are both amazing at that. I don't know how. I just don't have the endurance to do it.
Is that what makes a good gamer, though?
I mean,
No.
You have to define.
probably master them.
Pedantic as hell is what that makes us.
It's better. It's more endurance than I can put forward. That's for sure.
Like the problems of being a perfectionist is that like completion is
100%.
Yeah, because I know Katie can't go through a single building in Fallout without checking every little nook and cranny.
It's
I'm
true.
right there with her.
Yeah.
I'm like the squirrel. Like every time I see something shiny and new, I have to go run towards it. I
Absolutely.
The explorer. I drive people nuts when I play with them.
That's why, you know what? That's why we're good when we play together. We both understand.
Well, Mona babysat me during WoW Classic for a while. I was just this like, I was probably like 8 levels below her, and couldn't finish some of these questions. Like, don't worry, I'll heal you, and I'll drop my totems. Everything will be just fine. And it's like, all right, well, I got some stuff done. That's cool. So yeah, there's expertise there for sure. But a lot of that comes from, so back to the point of like judges and bringing things to judges. We were all talking about like certain contracts, and that's exactly what we're going to get into is agreements and EULAs, end user license agreements and things like that. But one of the things that came up was it depends on like what is enforceable, what is sort of something a judge will rule on, and like what sort of things go into a contract that maybe you see on a regular basis that you're sitting there going, why is this in here if almost everybody in the world knows that most states won't enforce these things? Or, I mean, you guys translate for me, I guess, but it sounds like there's a lot of things that get put into certain agreements where you're like, that's unenforceable. Why would they put that in there?
Well,
You'd be surprised at how much can be enforceable. And
yeah.
also keep in mind there's choice of law. So they're obviously going to pick a jurisdiction where it's going to be as enforceable as possible. And they also tend to include things like mandatory arbitration, which means that choice of law is going to be treated a little more loosely. It's not going to be as precise, and they're more inclined to rely on the choice of law in the contract.
Right. So, I mean, like, we live in California, which is extremely liberal and doesn't care about that whole contracts are like their own microcosm thing. Well, not as much as a state, I would say.
Depends on the contract.
Right.
Arbitration, they're totally against that. They have serious. California and arbitration do not get along, which is completely 180 from the national policy.
Right. But I would say that, yeah, choice of law is pretty much the biggest thing I'm concerned with, as far as enforcement goes. Because, like, we think we're protected because we're in California, but that might not be the case.
Arbitration is what you do when you don't want to go to litigation. Okay.
When you don't want to pay for litigation.
So I'm just when you don't want to pay for
explain this further, because there's a couple words in there I think most of us don't quite understand.
Okay, so you guys are under. You know what it means to mediate something, right? Arbitration is very simpler. Is very similar. Mediation is generally going to be. Mediation and arbitration are effectively the same things from a literal perspective. They're slightly different meanings legally. But mediation is kind of the far less formal, may not involve a third party kind of pre-negotiation before any kind of dispute resolution procedure. Then we go to arbitration, and in arbitration, that is kind of like quick court,
Yeah.
or courtroom light, I guess. You have 1 to 3 arbitrators usually. If it's a 3 arbitration panel, it's going to be one chosen by one party, another chosen by the other party, and then the third chosen by either both or the actual or the arbiters chosen by each will choose the third arbiter. And that person is basically going to hear the arguments. They're going to ask for evidence and discovery, but all of that is going to be on a far less rigorous and far less expensive scope than what you're going to have to deal with in litigation, and also costs just tend to be lower overall. So it tends to be faster, it's cheaper, it's mandatory prior to litigation in a lot of states, including in California, which I consider ironic.
Yeah.
But yeah, so it's preferable, especially in the commercial context. It may not necessarily be preferable in the consumer context because your remedies may be more limited and your ability to seek relief may be more limited, because ultimately, in order to get a judgment, if it goes to final judgment, then you have to actually go to the jurisdiction to get the order.
Right.
Like you go to the jurisdiction where you're trying to enforce it to get that order, and in order to get your payment. So it adds additional step on the recovery side unless you go straight to settlement through arbitration.
And I think most of arbitration most of arbitration is taken care of in New York when it comes to Twitch. I think that's where they choose most of their law.
Weird.
I don't know. I wasn't able to figure out why they would choose New York instead of California where they're based, but maybe
when they choose something that's not where they're based, it's literally because they like the laws there better.
Yeah, pretty much.
Well, right.
And with New York doesn't have the issues with arbitration that California does, which means that they are more likely to have arbitration clauses enforced in New York than they ever will in California. California is like anti-arbitration unless it's very, very fair and it's very, very specific. So it has to be super long, and it has to be pretty dense, and what they're asking for is not really beneficial for anyone. California has kind of a weird perspective on arbitration that I don't really appreciate.
So then let's talk about. So we're going to talk about streaming platforms and content creation platforms and gaming in general. Yeah, you like this? This is
Notice
Katie's
that
pen.
we both have the same pen.
Whenever I have these conversations, I have to have a pen. I don't even write anything down.
Exact same pen.
Yeah.
Same brand.
This is Katie's. I like this one. I steal her pens. I'm sorry.
Hold on. Before we move on, Dan, you said that Twitch uses New York.
I'm
choice of
pretty
law?
sure for the most part they do.
What do you know what contract that is on? Because on their terms of service it says Santa Clara County, California.
Yeah, and that's accurate.
Applicable
Applicable law and venue.
And then they use Jams for arbitration.
Which is what
Jams
they should be
is
doing.
a company that does arbitration, just like exclusively. Well, mediation as well, but alternative dispute resolution would be a key term if you're interested in non-litigation resolution disputes.
I mean, I don't think it's safe to say where I saw this, but it probably
Okay.
they've either changed it since then, or it depends on which one they're talking about, or which one they care more about for that reason, whatever it might be.
Okay.
But yeah, no, I mean, I think I do remember seeing the Santa Clara stuff because that was different from what we saw before. But the big thing with so I mean, let's get into this. Let's talk about terms of service in general. So when because we were talking about this a little bit beforehand during my stream earlier, where it was when you sign up to make an account on Twitch, you do or do not agree to all their terms of service as either a viewer or a content creator. Like, what are sort of the rules there when you're making an account?
Wait. Go back. I was still looking at jurisdiction.
You're right. So we were talking about like the things you may or may not agree with, right? Or agree on, whatever it might be. So when you create it, because you don't agree to anything when you hit the go live streaming button on OBS or XSplit or whatever it might be. So it sounds like we've seen this when you create an account on any of these streaming websites, you agree to something called the terms of service, or at least when you create something like that. What is the level of agreement you have there?
So actually, I'll let Katie handle the click-through enforceability question. That tends to vary from jurisdiction to jurisdiction. But generally speaking, click-throughs and contracts of adhesion like this are technically enforceable in the same way that when you get a plane ticket that has terms and conditions on the back, or a train ticket that has terms and conditions on the back, or like if you buy a ticket from Ticketmaster or something, there's going to be all of these warranties and disclaimers on the back. So or limitations on liability and disclaimers on the back. All of that is enforceable as a contract of adhesion because you are effectively agreeing to those terms upon accepting tender, so, or upon accepting the goods. So there's something called contract by performance. So even if there's no written agreement, there are going to be certain things, or acceptance by performance would be another way to put it. So by engaging in a particular pattern of conduct, you are performing certain things in connection with the agreement, or exercising certain rights in connection with the agreement, and therefore, because you are effectively accepting those rights, you must also accept the obligations. I just said I was going to leave that to Katie Gunn.
I mean, Katie, do you have anything to add?
I mean, I guess I could add that they've been ruled to be enforceable basically because at this point we've gone through so many of them, and I think that most of the provisions in these boilerplate contracts are generally known. Like, don't be a dick is one of the main things on TOS, right? And I think if you're like operating on the internet, interacting on the internet, you know generally that a website is going to, I don't know, be able to ban you in case you're being racist or whatever. And because you know that, and because you should know that, a court is probably going to be like, well, you kind of knew this going through. You clicked the OK button, consenting to this contract that you basically could have presumed had that in it.
Well, I mean,
But
it actually comes down to you are otherwise committing fraud if you say okay and then you've not read the EULA or the terms of service. I mean, you are saying that you have read it. So if you are turning around and saying, "Oh, I didn't actually read that," whose fault is that? It's not the company's obligation to
that's true.
verify if it's fraud that you read it or not.
I suppose my explanation is mostly based off of like this one court's discussion on it, where they were like, well, this is just an everyday part of life, and you just like click through these things, and you can't be expected to know everything in all the click grab agreements that you agree to.
Wasn't that the Sprint PCS agreement, or the Sprint litigation? TOS Sprint litigation? Pretty sure that's Sprint litigation.
I'm honestly sure. I just remember going over it in contracts and being like, I like this case.
The Sprint litigation is usually, I think, what comes up. There was another one that comes up a lot, but there are two kind of hornbook cases
Right.
that pop up in your treatises a lot. So
Yeah. But anyway, if it's a provision that's like so outrageous that no one would ever agree to it, that's usually when that section of the click wrap agreement is not enforceable. So that's all we're saying when we say that certain aspects of these agreements are not enforceable.
Yeah, certain courts will rule that certain provisions can't be in click-through agreements. That tends to be the more common way to regulate.
So I'm now at the sign up for a new account and stuff like that. And you put your username, password, confirm password, date of birth, email, and then right below that it says by clicking sign up, you are indicating that you have read and acknowledged the terms of service and privacy notice. And those both are hyperlinked.
Yeah.
That, I mean, obviously, not obviously, but that sounds like that's like enough, right?
So that process was actually discussed in depth in one of the cases, and I think it was. Oh no, you're making a face.
No, go ahead.
I think it was one of the cases that you're talking about, one of the seminal cases in this whole like click wrap debacle, where they were like, well, because you hyperlinked to it and you didn't show the entire agreement right before they were like forced to say okay, it's not enough. But I think since then they've ruled that it's fine.
Yeah. In most cases these days, it's considered okay. I have an entire I have several pieces of documentation actually, but one that I, especially for my publisher clients, rules and best practices for documentation display in games. And it's a fairly dense document, and it goes into the nuances of how you present things like terms and conditions and your privacy policy. And my number one rule is, one, make sure there are two boxes that you have to click and not one, because one, you need to actually accept the terms of, and two, they need to just acknowledge that they've read, because it's not a contract. You cannot treat your privacy policy as a contract. That will get you a fine of 2 billion, according to Google.
Ooh.
Yeah, 2 billion euro for violating GDPR by making a privacy policy your contract of adhesion. That is a big ass no under GDPR. GDPR is the General Data Protection Regulation of the EU. It's a mess. I'm not going into that right now.
It's beyond the scope.
Way beyond the scope.
So, no, sorry, you continue. Do you have more?
Oh no, I just was.
So what do you say to somebody? Well, so like a service like this where you only have to be 13 of age or older. If, let's say, a problem occurs somewhere, I don't know what would happen and who would charge a 13-year-old, but I'm assuming that's something that would even be there. Are they held to the same standards when they're presented the same stuff?
It's tricky because minors can enter into agreements to a certain extent, but in certain jurisdictions, they need parental consent to do so. They cannot contract for their own sake. They would have to contract through a parent. So whether it's enforceable against a child or not is kind of there are certain things that you so bearing in mind that most enforcement in connection with an EULA or terms of service will never get near a courtroom, because by and large these agreements are in place to say, this is we will ban you for this, we will terminate your account for this, and that's generally as far as most of these companies are going to go in terms of enforcement,
right?
Unless they experience significant financial harm as a result, or unless it's with an affiliate or a partner in the context of someone like Twitch, where they have a totally separate agreement with distinctive terms that are far more enforceable in the in that context. But generally, the greatest enforcement you're going to see in connection with the terms of service is going to be we're banning your ass, and that's it. Because trying to pursue litigation against a minor, for example, what company is going to do that realistically?
Yeah.
I mean, it's in the contract, but realistically, who's actually going to do it?
Well, it sounds like, and I'm just got to this point. After I asked the question, I was like, oh, there's a thing here. It does say in Article 2 that, because it's like right at the top, use of Twitch by minors or blocked persons. There is a large in caps thing that says, by downloading, installing, or otherwise using the Twitch services that you represent, that you're at least 13 years of age, and that your legal or parent or legal guardian agrees to be bound by these terms of service if you are between
Exactly. It's
13.
the parent or legal guardian that would need to be bound, because you cannot bind a minor in every jurisdiction.
And for the most part, like you said, they would just the account would be removed, right? But I mean, let's say because this happens quite a bit, it seems that minors tend to get their hands on scripts and start hacking people based on things that are let through Minecraft servers or whatever it might be. So I guess I don't know if Twitch would ever get looped into this, but it seems like that might be the connection. Everything would go to the parents, though, right?
Mm-hmm. Yeah, it's the same with torts. I mean, anytime you have a tort action against someone under a certain age, you are going to have to sue the parent and not the child.
Right.
Because the child is going to be deemed to not have capacity. And
Okay.
it's the parent's responsibility or the guardian's responsibility.
Yeah, I just realized that they actually had that in there. Okay, cool. So now, both of you have looked through a lot of the terms of service agreements and EULAs that we've based on a lot of streaming platforms and stuff like that. Before we get too far in the details, is there anything that pops out to you often that maybe a lot of people who agree to these and start making content on these platforms should be looking out for, or at least taking note of?
Katie, take it away.
Perpetuity.
Perpetuity? Yeah, it's a very
Just
strong
the
word.
word perpetuity. So a lot of these streaming platforms and particular company that we'll probably talk about later has started putting into their contracts. Sorry, my thoughts are quite jumbled right now. We'll just talk about Twitch so that I can focus on one thing and not get distracted.
Yeah.
So when you are uploading any content to the site, Twitch has in their terms of service that I think it's the Twitch affiliate agreement, my bad. So it's not in their terms of service as far as I can tell. But as soon as you start uploading content, they own everything in perpetuity. Let me read the actual language because that is very important.
I'm pretty sure it's live content exclusivity. It's exclusive to Twitch, even as to you.
It was licensing that
Right.
was focused on. So it's like they make it so that you can't. They don't need your permission to sell anything that you make to somebody else to make, or anything like that. So if they were to clip your show and then sell that clip, you wouldn't have to give consent, and you are not entitled to any back, as far as I can tell.
Right.
Let's see.
So, for an example, you see a lot of clips coming from the Twitch account main of showing, hey, this week Dark Souls came out, so here's a bunch of our streamers playing Dark Souls, and a lot of people who have their things on there is like, hey, look, I made it, I'm famous now. Twitch tweeted out a clip of me, and you can tell right then and there that most of that is a surprise, when in reality everything that is posted should be like permitted by you because it's your content, right? Well, that's the thing, is like, if this is within a contract of yours and you've overlooked it and just signed off to it, they don't have to tell you anything, and there's a big part of that serves as advertising for them, that they're pretty much, they can see a little bit, not directly, but they see a return on that, and you have no obligation to any of that, or you don't have to see any type of, hey, that's ad revenue that you probably got from that. Can I have a piece of that? And they're like, no.
I do want to point out that in Section 3 of the Twitch affiliate agreement that we were discussing, Twitch has the exclusive right to offer, promote, and make available your user content.
Yes, so you can't do it.
Well, yeah. So, in which such user content has not been bundled with any third-party content to end users and viewers of the Twitch services on a subscription, pay-per-view, or similar fee. Let's see. Twitch has the exclusive right to sell and/or display advertisements of any nature, advertisements in connection with your user content on Twitch services. So
What's interesting to me is that they don't specifically say likeness, do they? No, they don't. So this is like kind of hidden language, which is a fun thing for tracks.
Well, because when you're talking about something like becoming an affiliate, I think it's fair to assume you don't have a necessarily career going on in this platform, so you may not have the resources or funds to pay a lawyer to look this over and make sure that this is okay and everything. So is there possibly a moral problem with that? Or, I mean, obviously,
I have a rule where I won't, I mean, with the exception of necessary terms of service, if there's money involved and it's not just a straight like subscription service, or I'm just buying something online, I'm not signing, or I'm not agreeing to anything unless I can negotiate it.
Yeah.
I don't like signing anything where I don't have a choice on something like this, especially when I'm dealing with my IP. And like, for me, it's like what we were talking about before. Before the stream. I have issues where I have a very hard time licensing anything that I produce on an exclusive basis, because we are talking about legal knowledge that I use daily and that I am sharing with my clients and the, like, you know, whoever I'm talking to on a continuous basis. So I can't license that on any kind of exclusive basis for any amount of time, because I am constantly in use of that legal knowledge, and I'm going to be repeating myself in any context. So it's just it's not something that I can agree to with agreements like this. So I'll never be able to sign the affiliate agreement or the partner agreement.
Right.
Because Twitch,
and from what I understand is, well, so
they don't negotiate the affiliate agreement.
Well,
sure.
they claim that, oh, we don't do any redlining. This has happened in a conversation. I won't say where or how or when. This happened in a conversation that said, we, quote unquote, we don't do redlining. That should be probably one of the biggest flags in the world, right?
Oh, 100%.
Right. Well, I don't care if they don't do redlining. They better let me do some redlining.
Right, exactly.
Because I'll rip that shit up.
Right. Because, like, here's the thing. If you can't negotiate it, then there's a problem there. There's obviously somebody being taken advantage of. And there is nothing that says you can't go talk to somebody at Twitch to say, hey, can we talk about this and have this changed? But there's also not anything saying, hey, here, come talk to us. Here's a link to email us, or here's a portal to find us. You basically have to know somebody. So I feel like there's possibly, and this is not just Twitch. This is, from what I understand, this is pretty much everybody on the platform area, that says that if you want something, you're going to have to find a way to get special treatment, because it's not impossible, but it's pretty much impossible for a lot of different people. And I feel like that's kind of
leverage.
Oh yeah, exactly. And that feels like there's a lot of these companies get around these things. So if something's put in front of you, like an affiliate agreement, and you just want to be an affiliate and have a chance to monetize your stream, these are maybe some of these things to think about. And, well, if you're okay with it, then great. But if it's something that gives you the heebie-jeebies, remember that's not the end of the world if you don't sign that contract. A lot of us, who've been streaming for a long time never got an affiliate contract because there wasn't an affiliate program. When the partner program came around, I happened to have been lucky enough to know some people in the law world, and they looked it over and we talked about it, and we had some things happen, and we were able to, yeah, that's where I ran into a lot of things where it seemed complicated, and it's like, well, we should at least I'm allowed to have some of these things talked about, because everything should be negotiated, and if it isn't, I mean, is there any, like, there's no repercussions, right? They just pretty much say, well, if you want to negotiate this, we just won't have you sign it, and nothing will happen from here. Just kill everything that's happened.
It's generally, I mean, especially with something like the affiliate agreement, are they actually putting a contract in front of you, or are you just clicking?
Well, right. Well, that's kind of why I wanted to bring up this whole entire subject.
One of the reasons as to why companies have transitioned to click-through is so they don't have to have the debate on whether it's negotiable or not. If it's a click-through agreement, it's not negotiable, and you just need to accept that. That's how these companies operate.
Right.
You don't get to negotiate their terms of service unless they hand you a physical copy and say, here, you're allowed to redline this. Otherwise, you just assume that it's not negotiable.
So I mean, like, what do you even do? Like, you just have to say, okay, I guess I'm not doing this. Like, that's the
it's literally a take it or leave it proposition when it comes to click-through agreements.
Right. Which a lot of, I believe, partner agreements are like now too. Back when I was partnered, they actually, I'm trying to remember, I think there wasn't a portal, but there was an email with an attached copy of something, so we were able to talk through it and stuff like that.
And that can happen, and that's something that I've done before. I've completely modified terms, or what will typically happen is that there will be terms, and then there will be another agreement that is like the base agreement that needs to be signed, and in that agreement, I will have terms that override the terms of.
Is there any cases of people pretend to be? Oh yeah, that happens all the time. There's cases all over the place where people are attempting to contact you. But the thing is, I don't think anybody. I mean, if they do, they might, but it seems kind of stupid and very, very problematic if they do. But I don't think anybody's sent like fake contracts out so that you accidentally sign something.
Oh my God.
I haven't had that in any way, shape, or form in the context of streaming or video games. I have had that problem in music, where I had somebody claim that they were an agency representing music, or representing these musicians, to a promoter that had asked for legal advice, and she had hired me. And I looked at the agreement, and there was a stamped signature already on it. And I was like, that just no. No. So you could kind of tell, like, just reading through the agreement, you could kind of tell that it was just bullshit, and that there was no actual agreement, and that whoever had sent this was like an actual crazy person. So that was my experience with having like the false reference.
Right, because
That's horrifying.
Yeah, it is
It was
horrifying.
hilarious for us, because I mean, they were two of my best friends who are running a company in DC, and it's a production company. They do film production, and they were doing like music video and event production, and they were trying to connect with an agency to put on an event, and or to do something, and yeah, it was. Like, they were like, "Is this query legit?" And I was like, "Let me look through this." I was like, I'm gonna go say no.
Yeah.
I'm pretty sure this is a crazy person.
So, and the reason that I said it that way was because, yes, Dram, there are a lot of people that do contact falsely. Like, there's a lot of people that will say, "Hey, I'm from this company, and I want to sign you up for this deal, and let's get some of your information together." And the biggest thing to look for is the email. Most official emails are not Gmail accounts.
Yeah, you can also, I mean, you can fake emails too, unfortunately, to a certain extent. But one area where you really do need to be careful is going to be less in the corporate context, like the Twitches and the YouTubes and whatnot. And because if you get any kind of fake email or spam email from allegedly those people, it's all going to be regarding your account and trying to get your password, phishing. For these kinds of things where it's just people trying to literally take your money, or take ownership over your shit. And the true dangerous scams are going to be somebody claiming to be agencies or claiming to represent you or claiming that they're going to be able to get you these deals. Because I've seen a lot of those, and those are sketchy.
Mhm.
Those are seriously sketchy.
Oh yeah.
You
I
got to
get
be very careful as to what they're asking for, what they're claiming rights to, what they're saying they're going to do. If they're saying they're going to do anything at all, because most of them say that they're not going to do anything,
right.
but they still get 20% of everything that you do.
I get so we get monthly reports from OPG and the online performers group about like deals that we've been talking about, and they've been negotiating for us and stuff like that. And I'll remember like in our chat, I'll see, hey, are you interested in a game that is like this? And it's like, yeah, that looks really cool. And then on the next monthly report, I'll see something that says, oh, we're not moving forward with that because it seemed sketchy as hell. Because there's always something that comes through, and there's so many people out there attempting to take advantage. So yeah, there's always stuff like that.
Conversation a lot.
Yeah, I mean, in almost every one of my monthly reports, there's at least 2 or 3 of them. Of like, yeah, we're not following through with this because this is a bad deal. We're not any of that. Or there's a lot of, oh, they're not going to pay you. They just want you to do something for them.
Mm-hmm.
So yeah, that happens a lot.
Don't work for free.
Yes.
Right. And as much as it is, I've talked about this many times on this show specifically. It's tough to get somebody in the professional world like Katie or Mona to read something over for you and stuff like that. But I think there's a lot of information, especially the more we do this show, and there is possibly a show in the making of Katie and Mona doing their own thing there too, that there's something you can learn somewhere. But always feel free to ask somebody that may or may not know something, because you don't want to go in there thinking you're right and then end up just being totally taken advantage of. But so to move on, I asked Mona and Katie to do this show on Thursday or Friday, and just naturally, both of them were like, oh, let's start researching things. Let's do homework. And I was like, I've never had a guest actually do homework especially without me asking. So both of you looked over. Yeah.
I have 2-column documents of terms and conditions for like 3 different websites, and my notes on the other column.
No, exactly. That's what I want to get into. Like, so you guys both went into stuff, and we had small conversations about some of these. But what are some of the interesting things that you guys found? Because I asked them specifically. So I asked Mona specifically to look at the TikTok terms of service, because that's part of a conversation I had with somebody about TikTok. Is actually what sparked the idea to do this part. And
so
yeah.
So fair warning, I'm a little bit more defensive of companies like Tencent, because I understand the Chinese culture and the Chinese corporate culture, and quite frankly, when comparing traditional Chinese companies with Tencent is like the most liberal, left-wing, consumer-friendly, IP-friendly, like user-generated content-friendly, fucking good company ever.
Yeah.
At least in terms of Chinese business and
Sure.
corporate culture.
Contextually, yeah.
Contextually.
Yeah.
So I understand that Tencent is far more like a U.S. entity than most Chinese entities.
Sure.
So that in and of itself, if you are working with a Chinese entity and they are behaving like a U.S. entity, you are probably in better hands than their Chinese competitors. That said, are you in better hands than their U.S. competitors? That's a different story. We won't go there, and I won't speak on that issue, because I really like Tencent, and I really like it when we're on deals opposite them. So I want them to keep coming to my clients.
Sure. Yeah. I mean, Tencent they're huge, right? Like I was just reading that. By the way, Katie, a new Venom got announced.
Oh.
But also that they're a Tencent, like Sony's a Tencent company now, or at least that movie is produced partially by Tencent. And they try to do a lot of good things. They also do a lot of weird things, but they're all over the place. But the thing is, they're so big that it's hard to really nail down exactly what's going on all the time. Anyway.
Yeah, so looking at the TikTok agreement, I mean, I could go through this line by line, and I have with certain terms of service. But what I was talking to Dan about earlier, and one of the things that I want to do, so TikTok and Twitch and YouTube, whatnot, these are all very specific platforms involving user-generated content. You also need to keep in mind that anytime you're streaming a game, you need to look at your game's terms of services as well, because they may not actually allow streaming of any kind, especially if we're talking about a beta or pre-release or an early access. There may be some substantial limitations on your ability to stream content. So one of the things that I also wanted to look at was a video game studios EULA, or terms of service, so you guys can kind of see what that's like. So let me
The
throw that
Unbroken
link
Studios
up.
one? Is that what you want to put up?
The Unbroken Studios, yeah, their terms of service.
Okay, I'll put that. So
Hold
I'm
on
going
a
to put
sec.
a link to the website, and if you go down to the bottom, you'll see end user license agreement and terms and conditions. Click on that, and you'll be able to follow along with what we're talking about here.
Hey, Wes.
Hey, Wes. Wes, did you do your homework? Probably not. Slacker.
Did you do your homework, Wes? Did I give you homework yesterday? I don't think I did. So going through, but so I wanted to make sure that you guys could take a look at one of the, because that's an agreement I drafted. So if you want to take a look at one of the agreements I drafted, it's up there, and it's got both the EULA, the terms of service, and a privacy policy. If you want to see what mine look like, but what I want to do is kind of do a comparison of what the terms are in the TikTok agreement with regard to user generated content, and what are the terms in in a more normal context. So looking at the TikTok terms of service, do we have a link to? I can screen
I got
share
that one.
if you want.
I got a link to that one as well. So there's 2 links in chat. There's one for unbrokenstudios.com. You have to scroll down because that doesn't have a sublink.
Yeah,
but
that's annoying. I need to talk to them about that. That's super annoying if I can't link to my own.
It makes the website easy to scroll and stuff like that. But yeah, there's no quite link. And then so the TikTok/legal terms of use, that's the that'll take you to the whole legal section on terms of service, which is, from what I've seen, interesting. It's also long.
I don't really get into notes until section 7 when we get to content, because everything else is fairly standardized, right?
Yeah, right. Yeah, usually the first couple sections are that way, yeah. So content, that's important.
So unfortunately, this is terribly organized because there's no way to identify paragraph and paragraph.
Yeah, that was the first thing that stood out to me.
It's written like an essay, yeah.
Super annoying. So section 7, the second paragraph, you acknowledge and agree that we may generate revenues, increase goodwill, or otherwise increase our value from your use of the services, including by way of example and not limitation through the sale of advertising, sponsorship, promotions, usage data. Ooh, that's an iffy one. And gifts defined below. And except as specifically permitted by us in these terms of service or in another agreement you enter into with us, you will have no right to share in any such revenue, goodwill, or value whatsoever. They do not actually specify, like, it's kind of ambiguous if they are saying that about your content or your use of the services, and that's iffy. You further acknowledge that, except as specifically permitted by us in these terms, or in another agreement you enter into with us, you have no right to receive any income or other consideration from any user content, or or your use of any musical work, sound recordings, or audiovisual clips made available to you on or through the services, including any user-generated content created by you, are prohibited from exercising any rights to monetize or obtain consideration from any user content within the services or on any third-party service.
That one. I like that one.
You
become famous.
Content that has been uploaded to a social media platform such as YouTube for monetization. That is probably not enforceable on so many levels. It's interference with freedom of contract.
So there's a
It's assuming exclusivity without assigned writing, which
Right.
is in violation of the DMCA and copyright law. Because
Fun.
it functions as an exclusivity provision, right? You
Mhm.
can't use your own content anywhere else. You can't monetize it.
So
Placing
we see Jenna
fetters
Marbles.
on that.
No, I was just
What's
saying we
that?
see Jenna Marbles do a lot of watching of TikTok and making fair use content out of it, but she can never monetize it because what is it? What company is it that takes the monetization? UGM, the music company.
You is it? I
UMG?
thought it was
Are you thinking?
UMG.
Are we thinking BMI and ASCAP?
No.
No,
I was
she
gonna
said
say
UMG is the one that
Universal
copyright
Music Group.
strikes.
Yeah, I think that's it. But they take a monetization of her content on there. Even though I did watch back a video, I don't remember hearing any music on there. So I don't.
There's music.
Is there?
Yeah.
Okay. Well, even so, without like, let's say there weren't music on there, is this license agreement saying that she couldn't even monetize that video anyway?
Yes.
Yeah, pretty much. Like, so hold on, let me go down to the definition of user content. Hold on one sec. Time for search. Time for search.
There's a lot on there.
Yeah, user content.
I do read
I
these
just need to find the
contracts.
defined term.
Yeah, for
I
sure.
hate it when they say defined below, as defined below, as defined below. User so where is it fucking defined? Where are you going to define this?
Spoiler,
me where
it's
it
not.
is.
Here we go. User generated content. So users of the services may be permitted to upload, post, or transmit, such as via stream, or otherwise make available content through the services, including without limitation any text, photographs, user videos, sound recordings, and the musical works embodied therein, including videos that incorporate locally stored sound recordings from your personal music library and ambient sound. That is literally anything you can fucking stream.
Yep.
Yeah.
So they are effectively, and it's not even necessarily limited to user or content you have created through use of their services or
Right.
first or on their services first, like first instance. So they're claiming that you cannot monetize any of your own user generated content if you put it on TikTok, which means no one, no influencer, no streamer, anybody who is actually monetizing their content should be very, very hesitant to do anything on TikTok because you may be violating your agreement with TikTok by monetizing it on another service.
By
And
monetizing anything at all, because that's what it sounds like to me. I might just be like going way crazy with it. But
No, I think that you can read it that way. I think that no sane court would interpret it.
we're not talking about sane courts. We're talking about my brain.
well,
I know, I do the same thing, and I'm just like, nah, I can't do this.
Right.
Like, there's a common sense element that I have to interject because I can only suspend reality so far in the context of a term of service.
Right. And that right there is like the biggest reason I've wanted to bring this up in the first place was I see a lot of people using it as a promotional tool, right? To be able to say, hey, there's more users here. I can get a lot of the people who wanted Vine and now they have TikTok and stuff like that. So there's a lot of people finding traction through that. But at the same time, everything that you upload there is possibly, like you said, in violation of this user agreement. And what is the promotion you're getting through there to go to a different platform or whatever it might be? Is that worth it because of what we're hearing here?
I mean, so as I said, there's questions as to enforceability on stuff like this, and especially where the language implies any level of exclusivity, especially in terms of monetization and commercial use. That is going to require a signed writing under U.S. copyright law. There's no getting around it. There is no such thing as an exclusive license without a signed writing, and this is not signed.
Right.
You cannot be like, you actually need an actual signature.
I would like to kind of I mean, it's supposed to be law talk, but bringing it to a moral standpoint and a just general common sense standpoint, I don't think it's good for the future of the platform in general, like content creation, to use services like this that have these terms, regardless of whether or not they're enforceable, because if we just start setting precedent, like, oh yeah, we'll just sign something because we know it's not enforceable, and then they end up getting like a good judgment somewhere and it becomes precedent. That's it. Like, you're just done.
Right, because it only takes one judge to kind of change everything, right?
It depends on the level of court, but yes, kind of. So like if something were to go up to the Supreme Court and they would just determine, oh yeah, as if they would take a contracts case in the first place. But anyway,
They do with surprising frequency.
really?
Yeah,
That's
they
scary.
take on stuff all the time.
That's scary. Well, anyway, if they were to determine that this kind of stuff is enforceable, it would basically just ruin content creation.
So you're talking to every content creator out there right now.
Yes, yeah. If you have the intention or to be a content creator, you are a content creator, or you enjoy content creation, I think it's negligence on your part to participate in not companies, in services like this, and by just accepting those terms of service without I don't know.
Well, the other question is enforceability in terms of how much are they enforcing it? Like, how much are they themselves enforcing a policy like this?
That's true.
And is there a waiver argument?
Yeah.
I think that you can have a doctrine of latches argument and you can have a waiver argument. Doctrine of latches is you are aware that something is happening, but you've not and you've been put on notice that something is happening, but you do not act on it, you do not complain about it, you do not put them on notice that they're in violation of anything, you just let it ride until they start making a significant profit and then you see them. Yeah, that's called doctrine of latches, and that's a really big way of saying, fuck you, you asshole. If you were going to bring this up, you should have done it before we had invested all of this into it.
Right.
So that's my very earthy way of saying doctrine of latches.
Does that have anything to do with companies like... Now, Katie and I have talked about this, and this, so you know what I'm trying to say here. Anything to do with why companies take enforcement and they'll take little cases here and there to drive home that point of we are enforcing this so that something like that doesn't happen?
They won't go, like, they may not raise a claim against somebody who can fight them on it. They're generally going to go for somebody. You can't bleed a stone. The highest likelihood of success in enforcement is somebody who can't fight back.
Yep.
That's all there is to it.
Right.
So they're always going to go for the little dogs. They're not going to go for the big dogs. They don't want to fight against a Sony. They don't want to fight against an EA. They want to fight against a little tiny ass studio with 2 or 3 developers because that developer is not going to say anything.
Right.
To clarify for chat, I would like to point out that this is companies enforcing their rights by setting the example to other people, being like, oh yeah, we are actively litigating our rights in this field, and also so that when they go up against somebody for like a legitimate issue, a court is going to be like, well, where were you? Mm-hmm. And they'll be like, we were fighting these other cases, instead of
Right. They have now proof that they've been attempting to keep that solid for them.
Right.
Like, for example, I mean, Disney's one of the biggest people and they're one of the biggest entities in this category. They're just one of the biggest entities in general. But whenever we saw like Star Wars emotes being taken down from Twitch streamers, does that fall into this category?
Partially. Also, Disney is just like that.
Yeah.
Disney is super, super, super hardcore about enforcing their rights against anyone and everyone. So it's not just the little guys they go after. They go after the middle guys and they go after the big guys. They don't care.
Right.
If you are using their content, they are the biggest shark in the ocean. They are going to go after you. They don't have to worry about it. They are the reason copyrights are extended to the extent that they are, that they are so ridiculously long. Literally, it's Mickey Mouse. You can blame Mickey Mouse for the DMCA.
Yeah.
And the expansion of copyright protection.
I remember you had a comment about their takedowns of Mandalorian Baby Yoda gifts. Was that like, did it feel like just too much? Like, what is it just ridiculous? What's going on there?
It's just how they are.
Just typical Disney.
It's just typical Disney. Like it's they. I think they. I'm pretty sure they have a whole bunch of tools and technology that spend 24 hours, 7 days a week trawling the internet for image matches and like reverse image searches to find anybody that is using their content.
Right. Oh yeah, I'm sure.
I think that's just what they do. And there are other companies that do that, but I don't think anybody does it like Disney.
Right. Yeah. I would assume that's true. I mean, I'd be willing to bet that before Marvel was purchased by Disney, that people were getting away with a lot of Marvel derivative type things or Marvel use and whatever, what have you.
For sure, fan art and fan comics and fan fiction were big things,
and
it's a problem now.
that's
I'm a little worried for cosplayers now, especially in the context of Marvel, because Disney. I don't know how far Disney goes with cosplay, unless it's at their parks. They tend to be okay with cosplay at their parks, so long as you're under the age of 25.
Well, but think about how many people monetize cosplay through Patreon or what have you, through images. Like, what's the line there? You know, it's that's just so those are things to look out for. You know, like these are things that are going to happen in part of.
And that's another thing to take into consideration, because let's say you're playing a Marvel game and you're streaming it, and here's the messed up part, because keep in mind this becomes a multi-tier agreement, right? And you don't know how complicated these things can get, because you will have middlemen who can operate as licensors, or they will license directly to the publisher, or they will license directly to the developer. You don't know who actually has the license from Disney at any given time.
Right.
However, so whenever you're looking at the terms of service or the EULA may not say anything concerning use, like, that you are prohibited from creating user-generated content based on the IP. But if it's licensed from Disney, then very likely their license with Disney is going to say that needs to be in their EULA or in their terms of service, so that they cannot take that content. Otherwise, it needs to be silent on it and just assume that they can't, and Disney will probably go after them. Like, that's the thing, is that, it's not just games in general. It's going to be the underlying content as well that you have to take into consideration when we're talking about streaming a game, for example.
Right. Yeah. Because, well, I mean, we've talked about this probably before, where it's like in some aspect, streaming video games in general is, the word isn't illegal, is it? It's
a violation. I mean, your agreements.
Yeah, it's a breach of contract.
Right.
Wait. Wait. So if we're talking about infringement, it's just infringement. I mean, whether it's either tortious or it's criminal, depending on.
Well, right.
So, what I'm getting at is, like, so any streamer that plays a video game on their stream, I mean, obviously there's all kinds of weird stuff, and I still don't understand free use as much as a lot of people think they do. It's way too complicated, I think, for a lot of people to understand. But essentially, from what I understand, when we play video games on something like Twitch, it's mostly the company seeing that is more beneficial to not do anything about than it is to do something about.
That's why I tell my clients, and if you look at that Unbroken Studios terms or end user license agreement, actually, it's in the EULA. If I can open it.
I'll ask you what the difference is after this. Yeah.
You will see. I think I actually have an allowance for it. I don't know if I have it in this one. It might be one of my other ones, because this might have been a pre-release when I drafted this. Pretty sure this was a pre-release. Anyway, generally, whenever I have these things, I will have a section in there for modding and for streaming, allowing that kind of thing. I don't know if it's in this one, but generally speaking, that'll be in there. And it's something that, I talk to my clients about a lot. It's is this going to be useful for you? Are you giving up a free means of marketing And the only time that I would ever recommend it is if you are at pre-release stage and you don't want people trash talking your game because it's still got bugs.
Right.
Otherwise, I can't see the benefit of not allowing streaming.
Right. So would you say that Let's Players and streamers of this sort have kind of created a culture that sort of bypasses the whole agreement section, kind of, a little bit?
I would say that.
Mm, to a certain extent that, but also because I think one of the issues as to why it's not enforced and very few people go after streamers and Let's Play is because nobody wants the precedent of it being called fair use.
Right, right. Exactly. Because fair use seems like a very loose, weird thing that seems to change frequently. I don't actually know.
It's
Every time I've seen a free use case like be talked about, it's always something completely different. So
Well, especially with streaming, because you are playing such a significant amount of the game,
right,
if it's ruled as fair use, it's a massive problem. So
Yeah.
there is actually a lot of justification for not wanting to litigate, especially
right,
considering the scale of streaming at this point and Let's Play. And I mean, way too many companies, like in terms of the social good and public policy, and those are considerations.
mm,
Uh, in terms of public policy, it's far more likely that a court would want to rule in favor of fair use because of how many people would be impacted if it's
right,
not.
right. Well, there was that it wasn't a case, but it was I guess a talked about thing. Who knows what they call things that are popular on Twitter now, about the streaming of Persona 5 when that came out. For the first like 6 months or something, people were not allowed to stream. What is it? The first like 2 or 3 days. Do you remember that, Katie?
I think it's the entire anything. You couldn't stream anything.
You
of the
were
game.
you were able to stream to a certain point, but it was like still very early in the game.
Well, I remember when I was playing it, there was like the internet connection or whatever it was would shut off. Like the ability to stream would shut off when I entered a cutscene. So those were off limits. And I think initially you couldn't stream it at all. Like I really think that's what it was. And because otherwise I don't think people would be that outraged, would they?
Oh, they were pretty outraged, and it was, and people streamed it, but they were like, I'm 3 hours in, I can't stream anymore." So most people either didn't stream it or were just mad that they couldn't stream it any further. So it was almost like they were streaming a demo, which made a lot of people a little upset. Which I mean, that the reason to talk about this is to say that they're fully in their right to be able to do this.
Yeah.
Mhm.
But also that just seems, I don't know, for me as somebody who doesn't even like spoilers like at all, that just seems like good business sense on their part because they're like, well, I want people to purchase my game to experience it for themselves, and if they're just watching other people play it. But I mean, like,
Yeah.
it honestly doesn't matter because if you're going to play the game anyway, if you're going to play the game, you're going to buy it anyway. Play it. Which is like the whole argument for streaming in general. I don't know why I'm looking at you from that direction.
Because I did the same thing.
All I know is that like the dissonance, because I'm watching the stream and I'm not watching the Discord. So like the dissonance between I need to stop doing this. This is giving me like a massive headache. There we go.
Yeah, not to mention, like, sorry guys for the picture. It's not supposed to look like this. I don't know why Discord is doing this, but it's all blurry for some. It was fine before we started. I don't know. Anyway, these guys, they look like normal human beings, despite what Discord is saying the world is. But I mean, yeah. So these conversations we can have for absolute hours, and I hope you guys do have this on your guys' show. But we want, before we like fully wrap up, do we have any things maybe on the top of the mind that should be looked out for, or some of the things on some of these platforms that maybe like you should maybe have at the top of your head while you're either creating content or before you even create an account on these websites?
Katie, go.
Well, definitely always look for.
Doesn't
I
TikTok
suppose I should.
Doesn't TikTok have an in perpetuity clause?
I mean, probably, but
I know
Yeah,
Valorant
their
does,
use is
which
perpetual.
okay, so I don't want to give you guys buzzwords because while I do like a control find on a lot of contracts just to see if they do have those buzzwords. It's not always going to be fully protecting of you, because the way that people draft contracts sometimes is that they like to hide the same meaning in different language so that you can't find it, which obviously is not good faith, but sometimes that's still something that you can be bound to.
There is an implied meaning and there's an express meaning.
Right. Thank you. But you always want to be looking out for what the contract is allowing you access to, what it is. Well, I guess it depends on the type of contract, obviously, but let's say for Twitch, a streaming platform, if you're signing a contract to partner with them or become an affiliate with them, you want to see how it affects you and your ability to make content.
And monetize.
And if that extends, like the TikTok agreement, to other platforms or other use of your content, what that platform can do with your content, whether or not they are seeking, or well, I guess seeking is the right word, complete and utter ownership of the content that you're creating. And I guess if you're actually looking to sign the contract, you want to talk to a lawyer about it. Like, if you have any questions whatsoever, you should be talking to a lawyer. Even if you don't have questions, I would recommend you talk to a lawyer, but that might just like, I don't know.
Thank you for the disclaimer, Wes. I desperately needed that. My philosophy, I was going to go into this at the beginning, but I think this is actually a better way to wrap up. I have some very hard and fast rules when it comes to contracts that I draft. There is going to be a certain amount of legalese in a contract because certain language is legally operable. Outside of the legally operable context, if you cannot understand something in an agreement, you either need it written in a way that you can understand, or it needs to go away. The entire purpose of a contract, and this is something that I think even law students or even attorneys have a difficult time grasping, is that a contract is a legal document, yes, but it doesn't have to look like a legal document.
Right.
A contract's sole purpose of existence is to memorialize the understanding of the parties. So if there's a party that does not understand what is going on in the contract or what a particular provision means, the contract is not doing its job and it needs to change. A badly written contract is a contract that is not doing its job, and that is 95% of the terms of services you're going to find, unless they're mine, in which case they're perfect.
Right, because if somebody comes up to you and says, hey, we're going to agree on something, and they put out their hand and then they mumble the ingredients, like they mumble what you guys are agreeing on, you're not going to shake that person's hand and try to keep yourself to honor that, right? Because you have no idea what the person said. So, yeah, if there's something in a contract that you don't understand, and especially when somebody doesn't want to rewrite it for you so that you do understand, it's a problem. You're not going to shake that hand, so you're not going to sign that contract, and that's something that's going to help you protect yourself. This goes a lot of different ways. I think personally, when it comes to the things that we're doing right now, and because we're almost literally in the wild, wild west for still this content creation world, that there are a lot of agreements, EULAs, and terms of services that we can go over and talk about. And this could very easily be something we talk about every week for the next 6 months. But I think for now, that's kind of the way that you can re-listen to a lot of this. There's a lot of information that I didn't understand, I'm gonna be honest. But it's at least recorded so we can listen to it again. But there's a lot of things that if you're even if you can't find somebody to ask, or it's not going to happen, maybe the person's busy until next week, it's not something that is going to end the world if you don't agree to it or you don't sign it just yet. This goes for affiliates, this goes for partners, this goes for anybody on any other platform.
Rule number one of contract negotiation: never get desperate.
Yes.
Yeah.
Because that's when you're just going to get taken advantage of. If if let's say you've been an affiliate for a couple years and you've been offered partnership right now, I'll tell you that your contract does not look like mine. In fact, it's changed probably 3 or 4 times in the last 2 months, or maybe a little bit longer than that. But still, it's changed quite a bit. It looks nothing like mine. So read it over before you just say, "Hey, I'm a partner now," because I'll tell you right now, you don't want to become a partner if it costs you a lot of other things. Take a second, refer to somebody, and go over it with them, step by step, line by line if you have to, section by section, and make sure you're not signing your life away, because in a lot of ways, you kind of are if you don't really change things, because likeness is not just your content. Likeness is you and what you look like, what you sound like, who you are in a lot of ways. If people have that access to those things and you don't like it, you are shit out of luck. Pardon my French, but you're shit out of luck because you signed it away.
It's also super sketchy to ask for perpetual use of your name and likeness in the context of an online service because of things like GDPR, where you are legally obligated to delete personally identifiable information, and name and likeness sure as fuck is personally identifiable information, period. Obviously, that is actually what PII is. So that's a question as to whether it's even, whether even they can make that claim, because they may actually be legally obligated to delete this information at some point.
Right. So take that into consideration. Think about what you do and how you do it. And if you make content on this platform, I'm willing to bet you're pretty proud of it. And you want to be able to own as much of that as possible, as much of that as you can, if not all of it. So be careful. Make sure that you're being diligent in everything that you sign. Obviously, there's a lot of video game stuff out there that you just click through because you want to play the newest game that just came out. We'll get into what goes into those things maybe another time, because that's a whole different thing. But yeah, there's a lot of these things. Sweet Rotten Robin, I have a story that I don't think I can tell on the internet right now that says yes. There is a lot of that stuff that goes way over people's head, and they don't really think about it, and they just sign it because, hey, they're going to be on an American Idol or whatever it might be. So take that into consideration.
Perpetual exclusive use of your name and likeness for any purpose.
Feels like slavery. Just
is slavery. Indentured servitude. Closer to indentured servitude than outright slavery.
Yeah. And your payment is the chance at a prize. Unfortunately.
It's gambling too.
Oh yeah. There's a lot of that. Like there's a lot of those agreements that the payment is not a payment unless you quote unquote earn it.
Yep. Isn't that so cool?
Yeah. And not to say that who knows if I mean, here's the thing too, is like, if you sign something that has something like that, and let's say you are really talented, but the crowd doesn't like you and they get bad ratings whenever you do something like big, or you're part of the bigger part of the episode, and they decide to rig a way to let you go in the next episode because of that, even though you're really good at what you do, sorry, you lose out. And there's nothing you could do about it if you sign something like that. So, yeah, be careful. Anything else you guys might want to close out with?
I mean, I can go for hours.
I know.
Like, this has been my life for 11 years. But I don't want to.
Well, we should say that, like, Mona, before you did video games and that side of entertainment, you've been working in entertainment even before that music side. So you kind of see a big spectrum of entertainment.
I worked at Lionsgate too.
Oh,
so I've done film, I've done music, and I've done video games, but I've done video games the most.
Would you say it's your favorite?
Oh, I can't believe you're asking that question. I mean, yeah. Like, I don't even like people in the music and film industry. I have like 2 friends who work in film, and that's it.
Right.
Like, I don't like, and they're not lawyers. I hate I hate film and music industry attorneys. Like, not all of them. The women I tend to get along with better, but like the entitled old men who decide that I am their secretary and therefore all they need to do is chicken scratch on a physical copy of the document and then
Hollywood.
badly scan it in and then have me redline it for them.
Yeah.
I'm venting, and I'm about to.
No, absolutely. So all 3 of us have a mutual acquaintance that has worked with actors in the law side, and that person that is has some stories about how some of these actors might be and stuff like that. So definitely.
Because I do voiceover talent agreements and motion capture agreements for like the Kingsglaive, the Final Fantasy 15 prequel movie.
Oh yeah.
With
Chet, Mona's a huge fan of Final Fantasy, nerd.
Well, okay, but I negotiated and drafted the voiceover agreements for Lena Headey, Sean Bean, and Aaron Paul, who were the lead characters, who were the lead voice actors for that. Actually, their agencies were pretty workable. There's a funny story about that because I work with an agent on the publisher side who works with me to negotiate these agreements with talent on the talent side. So he's basically like a handler for talent on behalf of the publishers who are engaging these voice actors as talent. And he was telling me the story of Sean Bean in the context of Kingsglaive and getting the script as we're getting ready to do the term sheet. And apparently he kind of agreed to do the role before he'd fully read the script.
No.
And he gets to the end of it. He was like, it was something like, "Oh, bloody hell, of course." It was like, yes, he dies in it.
Yeah.
He dies.
He
always dies.
Well, there's a whole marketing campaign with one show he was in where the marketing campaign was Sean Bean doesn't die in this.
Honestly, I'd watch it just for that.
Right? But anyway, I've been Dan Otage, your host right here on Dan's Stream of Thought, talking about terms, conditions, and you. There's lots of them, and there's lots of you, and you're all important, so make sure you protect yourselves. I've been joined by the lovely ThatOneKnave, Katie, which you've seen in my chat, but you've also seen her streaming on her own channel at twitch.tv/ThatOneKnave, all Knave, all spelled out. She's amazing. She's also Lady Laumies on Twitter. We got to get around to changing that for you. So go follow her there.
Twitter.
No, you can actually change the name pretty easily. So go
Do
follow
I
her
want
there.
to?
And you'll see her retweet and Tori talk about some cool law stuff that you may or may not be interested in. Probably a lot of animal things, so everybody loves that. And then you can follow Mona here on Twitch as well. She streamed today. She streamed some yoga today. I hope that went pretty well.
Yoga. I've been streaming yoga every day during the shutdown just because it's the only way I'm going to do it and stay sane.
Well, it's also like it's such a thing that I think a lot of people could use. Like just even if they don't do the yoga with you, they're just sitting there relaxing with you, which is pretty awesome. Because there's a lot of gaming on here. You can always find a lot of gaming content, but just alternative content like that is pretty good for just anybody stuck at home doing stuff or doing nothing. But you can follow her at _cherished right here on twitch.tv. But you can also follow it's lawtaku_ESQ for Esquire, also here on Twitch, where you're going to find actual law stuff and law conversations, probably a lot like what we talked about today.
It's a work in progress. It hasn't really started anything yet. We're still in that process.
We'll all sit together and come up with something that I think you'll enjoy. I think that'll be cool stuff, because as much as we talk about a lot of crazy things on here, there's a lot of law stuff I don't feel comfortable with unless I have somebody like you guys here on the show with me. So we'll go follow all three of those channels. And like I said, I've been Dan Otage, DANOTAGE. Oh, you can follow Mona on Twitter at Mona Ibrahim. Her full the name right here you see on the corner there, that's on Twitter. Go follow her there.
Just get rid of the space.
Yeah, no space. All one word. So yeah, follow all the things. I hope you guys had a lot of fun today. There's a lot of information that went out. This is actually, my throat doesn't hurt today, like most Dan's Stream of Thoughts do, because, well, I have got a lot of knowledge that has come out of both of these lovely ladies that I don't have to spit out, because I don't know them, for one. These guys know way more than I do. So that's been pretty great. We'll be back next Tuesday at 6 p.m. Eastern, 3 p.m. Pacific. I don't have a plan for that show either, but who knows? Maybe these two are free again. We'll talk more about some other stuff. But thanks for watching, thanks for hanging out, and thanks for being here. Remember to stay positive, play more video games, and read more comics. I'll see you next time. Goodbye, everybody. Bye.
Thanks, everybody, for coming, for joining the stream. Follow us on Twitter, and if you have questions,